I have a couple of brief instructions to provide to you, and then we will begin with opening statements this morning. As you can see, you have been provided with a notebook and an ink pen. Those notebooks are for you to take notes throughout the course of this trial. Those are the notebooks I referred to yesterday when I asked that you, if you take notes, that you do so only on the paper that we provide to you. There's also some forms in there for questions at a point when witnesses have concluded their testimony. If at any time during the course of this trial anyone needs to take a break, just give me a signal and we will accommodate any need that anyone has for such a break. Finally, I have one instruction that I would like to provide to you as follows. Plaintiffs brought this lawsuit against Ernst Young and against these other entities: Tremont Group Holdings, Inc., Tremont Partners, Inc., Oppenheimer Acquisition Corporation, Massachusetts Mutual Life Insurance Company, Goldstein, Golub, Kessler and Company, and KPMG LLP. You may hear testimony about these entities during this trial. These entities are not participating in this trial because the claims involving these parties have either been resolved or will be resolved in a different legal proceeding. You must not speculate about how such claims were or may be resolved, or whether or not any party has any other source of recovery available to it, as this has no bearing on any issue that you must decide. You are not to make any award or increase or decrease any award because you believe that a party may have some other form of compensation available. Even if there is such funding available to a party, the question of who pays or who reimburses whom will be decided in a different proceeding. You are only to consider those questions that are given to you to decide in this case. With that, I will ask that you direct your attention to Mr. Thomas. He will provide the opening statement on behalf of the plaintiffs, Futureselect. Mr. Thomas.
Thank you, Your Honor. Good morning. We're going to use the mic again today, and hopefully that'll make sure everyone can hear. Before I get started, I do want to introduce you some people who you'll see throughout the trial, so you know who they are. And the first person I want to introduce you to is Keith, who will be helping us do everything that goes up on the screen. If there's any problem, I can promise you that it's my fault, not Keith's. He will help us throughout the trial. And pretty much our whole firm is sitting right here, so you will see them in the back row. We have Ben Forrester, who you might guess is Mark's brother, and David Schillinger. We're missing Steve Sorensen, who was here earlier, but I think he'll be here later today. I'm going to prove to you that Ernst Young had a job. I'm going to prove to you that Ernst Young didn't do their job. And I'm going to prove to you that it mattered. The evidence will show that Ernst Young signed its name to $4.2 billion of fake assets. Ernst Young knew that the plaintiff, Futureselect, was counting on Ernst Young to do its job and say whether those assets were real or fake. We got the opportunity to ask questions before this trial of Ernst Young's now partner, but the person who at the time was doing the most work. And that's what I asked him. His name is Nicholas Bleddy. And I said, now you understand that in doing your audits as a certified public accountant, that at least some people are counting on you to do your job. And he said, yes. I said, who do you understand is counting on you to do your job? And he said the investors within the entities. That includes Futureselect, the plaintiff. You all know by now, this case involves Madoff. And y'all probably know that there's been lawsuits all over this country. And lots of people have taken responsibility for what not doing their job. In this case, as Your Honor just instructed you, the person left before you is Ernst Young. Ernst Young, in this courtroom, is the only one left who doesn't take responsibility. Ernst Young certified $4.2 billion in fake assets, and they say they have zero responsibility. Futureselect, who made the investments, takes responsibility. We're not going to argue to you, and I'm certainly not going to say to you, but the only person responsible for what happened to Futureselect here in Washington is Ernst Young. In fact, there were many factors and many people. What I'm going to prove to you is that Ernst Young was a factor. A factor. Because they didn't do their job. And because they didn't do their job, they bear some responsibility. And for you to decide whether that is reasonable, I need to show you what their job was and why it mattered. So that's the first thing I'm going to prove to you. First thing I'm going to prove to you is that Ernst Young, which I'm going to abbreviate as EY, had a job. Now, when investors make decisions to invest money, they consider a lot of factors. One factor they consider is how much of a return they're going to get. They look at whether the investment strategy makes sense to them or not. They consider whether or not for their type of investment it makes sense. But a baseline for any investment is whether it's real or fake. If you're trading or you're making a decision on an investment and you see, hey, it has a 9% return or a 15% return and there's risk, you can consider that. But the evidence will show that if you're making a decision, that first baseline has to be whether or not it's real or fake. When we were here, someone out there made an analogy to investing about going to Vegas. I don't know if y'all remember that. But you go to Vegas and you're taking on risk. And I'm sure y'all all know this, but in case you don't, when you go to Vegas, the odds are against you. That's how they build those big casinos, okay? And you know you're taking on a risk. But no one would go to Vegas and pull the lever if it was monopoly money coming out. That's not a risk you're taking on. Here, what certified public accountants doing audits, Ernst Young, the defendant in this case, does, is they provide that first baseline. When you look at an audit, you think those numbers are true. Now, I'm going to decide whether this is the right investment for me, returns, those sort of things. And that's what their job is. And that's what I'm going to prove to you. So in this case, this is how the investments work. Futureselect, which is the plaintiff, invested in broad market funds. The young lady who was sitting back here when we were doing it, remember her nephew had invested, and she sort of explained this as part of our questioning of her. Because you couldn't just go to Bernie Madoff and put money in, and you had to have a group. And what you did was Futureselect invested in broad market funds, and broad market funds turned around and invested the money with Bernie Madoff. That's how this worked. Ernst Young, and we just seen Mr. Gwetty, Ernst Young audited the broad market funds. And so, what's an audit? What's their job? Well, in auditing the broad market funds, what Ernst Young does is look at the financial statements and says whether there's reasonable assurance. A financial statement is simply assets and liabilities, a bunch of numbers and words. I know most of y'all know this, but it's assets are what you got. In this case, you're going to see United States Treasury bills, or stocks, or cash. And liabilities are what you owe. Loans you have to pay back, those sorts of things. And Ernst Young's job is to audit that financial statement. But why does Ernst Young and certified public accountants matter so much? Because they're the gatekeepers. That's literally their job. And that's how they're characterized. Certified public accountants like Ernst Young, the evidence will show, form as the gatekeeper between companies like Broad Market and investors. And the reason is the annual financial statements of a company do not go to the investor until certified public accountants put their name on the financial statement and say that these financial statements are materially correct, that there's no material misstatement, and that the auditor has reasonable assurance that that is true. That they have looked at evidence to make sure that in their expert opinion, the financial statements are not misstated. So the financial statement, the annual financial statement, cannot even get to Futureselect here in Washington, or Mr. Madoff in New York, until Ernst Young signs their name. Only after Ernst Young says, okay, we've reviewed this, we have evidence, we've gathered, and the words you'll hear, evidential matter, only after that, when Ernst Young puts its stamp of approval and signs its name, does the financial statement reach Futureselect and other investors. And only then do the investors put their money in. This happens on an annual basis. Okay? That's what the role of certified public accountants doing audits is. And that's why they matter. So the important part of this here is who can do this specialized role of auditing, being the gatekeeper. We've had a lot of sophisticated people about finances and other things in our room the last few days. And it's important to know that to do this special function of an audit, that not just anyone can do it. First of all, you have to go to school for a long time, take a very complicated exam. I think we heard someone out here who had taken an exam. And then you have to be licensed by the state. That's the first thing. Having a Master's in Business Administration MBA doesn't entitle you to do an audit because of its importance. Judges, you will find that no one respects the court more than the parties here, but judges can't do audits. Talk about regulators like the Securities and Exchange Commission. They don't do financial audits. It's certified public accountants. And of course, Futureselect here were not certified public accountants and could not do the audit. The only people that can do the audits are certified public accountants. And that is the gatekeeper role. So I want to prove to you that Ernst Young's job is to do these audits. And what does the audit do? Why do we have them? This is an actual rule from the auditing. Now today, I can only give you, over the next little bit of time, show you what we're going to prove. I'm not going to be able to hand out every document, and neither is the other side. So I will show you portions of the rules as we go through the day. I want to make you comfortable that anything that's admitted in evidence, Her Honor will provide to you at the close, and you can see it yourself. Okay? One of the rules for auditors is consideration of fraud in a financial statement. One of the things that auditors are supposed to do is at least consider and try to find fraud. And what the rule says is the auditor has a responsibility to plan and perform the audit to obtain reasonable assurance. This is an important point. We're not going to try to prove to you or tell you that Ernst Young was given a guarantee or that they're like an insurance company. That's not the rule. For you to find for plaintiffs here on this issue, you need to find that what they did was objectively reasonable. Not just what they thought in their head, but it was a reasonable thing. They had evidence for it, but not that it was a guarantee. Understand? Don't hold them to that standard. You hold them to a reasonable assurance standard. What they had to do was reasonable. About whether the financial statements are free of material misstatement, whether caused by error or what? Fraud. Free of material misstatement. That there's not a misstatement that matters. So if this case was about, they said there was $1 billion and it turned out that there was 999 million and they were off by like 200, then we wouldn't be here. Because that's not material. Their job is to give reasonable assurance that the financial statements they sign their name to are free of material misstatement, and whether caused by error or fraud. In this case, what they have to do then, after making this step, is do the number one thing auditors do. Are the assets real or fake? And there's a rule for that too. And that rule says that the number one thing, do we have that one? Oh, we're having a technical problem. We'll do it on that side. I apologize for the delay.
Let me know if you need to take a recess.
Thank you, Your Honor. This is going to be a policy, so we can take a recess. Your Honor, Keith is asking, would you please take a recess?
Certainly. Ladies and gentlemen of the jury, we apologize for the technical difficulties. Please leave your notebooks here behind you. This is our first recess during trial, so I'm going to give you the recess instruction that you will hear innumerable times throughout the course of the trial. Please do not discuss this case with each other. Do not discuss this case with any third parties. Do not do any independent research. We'll be back with you as soon as we possibly can. Mr. Thomas.
Thank you, Your Honor. Thank you for your patience. Let's get back to talking about what the evidence will show. Let's put some evidence up. So this is another auditing rules that Ernst Young had to follow in this case. And this rules says, as a long name, auditing derivative instruments, hedging activities, and investment in securities, which is what our issue is here. And the applicability here is basically sort of Auditor 101. The evidence will show that the applicability here, this standard applied, and the first thing that Ernst Young was supposed to do was determine whether these securities existed. Were they real? Were they fake? First rule of auditing. Determine whether the numbers on the balance sheet, they say they're in securities, do they exist? And here is one of the financial statements. Ernst Young audited 4 years, so year after year after year after year, they signed their name. The financial statements that look like this. And the evidence shows that in this particular year, 2003, the financial statements said that there were investments in United States Treasury bills. And that those Treasury bills totaled $831 some odd million. And what Ernst Young said, in their opinion, the financial statements referred to above present fairly, in all material respects, the financial position of American Masters Broad Market Prime Fund, one of the two funds. And they sign their name. And we're going to prove to you, I'm sorry, can we go back to that just a second? We're going to prove to you that that number wasn't a little off or kind of wrong. It was completely fake. The number should have been 0. There weren't any Treasury bills. And we will prove to you that Ernst Young did not have reasonable assurance, the evidence, to sign its name. Because what did they do? What happened with that financial statement? Ernst Young put its letter on top. It said, we're going to tell you our opinion on the financial statement. It even tells you how. We're going to plan, and you can see the whole thing. I can't read the whole thing. I just don't have time before it will have to be done. But to plan and perform the audit to obtain reasonable assurance that it presents fairly. And who did they write that to? The partners in the fund. And that's how you invested in this fund. You got limited partnership interest. The partners in the fund included Futureselect, the plaintiff. So they addressed this letter directly to Futureselect. That was their job, to say whether those T-bills were real or fake. Ernst Young's job was to give reasonable assurance of no material misstatement due to fraud. And I want to make this clear here. We are not going to try to prove to you that Ernst Young should have unraveled the whole Madoff fraud. That is not what we're going to try to prove. We're going to prove that when Ernst Young signed their name, they didn't have reasonable assurance to do so. They didn't have the evidence because they didn't follow the rules. Ernst Young should have never signed his name and issued that opinion. That's what we're going to prove to you. Fraud, difficult to detect. The rules will say that where there's a collusive fraud, it's hard to find. That there's fake documents, it's hard to find. But you got to at least try. You have to follow the rules. And on this, if you find that Ernst Young followed all the rules and did the job they were supposed to do, rule for them. Okay? rule for them. But if we prove to you that Ernst Young didn't do their job, they didn't follow the rules to have reasonable assurance to sign their name, that's when we'll ask you to rule for us. So what's Ernst Young's job? It's reasonable assurance. And that's the first thing we're going to prove. Now the second thing we're going to prove to you is that Ernst Young failed to do its job. Almost ran over. So let's see what they did. The first way Ernst Young failed to do its job is it certified billions in fake assets. That's going to be undisputed here. Remember Mr. Blade? I showed him this financial statement, and we're only using one, but there were two each year, year after year after year after year. And I said, if we look over at this page 1198, we see under assets, investments at market consisting of U.S. Treasury bills, and it's roughly $831 million. Do you see that? And he said, yes. And I said, and you understand today that that number is basically all fake, right? And he had to say yes. Madoff didn't buy any securities. He didn't have any. It was all fake. The number should have been zero, and Ernst Young never should have signed their name. This would be a good time, I think, for me to give you a little description of what the evidence is going to show about how Madoff pulled off his fraud. This is how it worked. Mr. Madoff would get dollars in from investors. Now, it took Mr. Madoff a while to get the money in. And when he first started using funds, right, he had auditors who came in. Ernst Young was not the first auditors. We're not going to prove that to you, right? Other people have responsibility here. We're not going to ask you to hold Ernst Young responsible for that, just for what Ernst Young did. Okay? What Mr. Madoff would do is he would get the money and he would put the cash in his pocket. He literally took the cash and put it in a bank account. And he would take a little bit from Mr. Madoff and his family. And then what he would do is he would never actually go out and buy or sell anything. What he would do is he would just take statements, look at what the market did that day, and write up pretend trade bills, write up pretend statements, and just type them up on Madoff paper. He had a company, Bernard L. Madoff, and he had Securities Inc. He would just type up as if he made the trades, but he never made them. And so what he'd do is look out in the market, well, what are T-bills trading for today? And he would see it, and he would just pretend he bought them at that price. That was it. And then he would send out those statements to people who would record them down, like the Rye funds. And then what he would do, because he'd have to pay back his investors. They were supposed to be making 9% or 10%. So he'd take the money from the first investors, and he would pay some of that back, right? He would take the money from them, pay that money to, I did that backwards, let me try again. He would get money in, take a little bit, he'd need to pay them back, so he'd go to this next set of investors and say, you want to invest in me, give me more money? They would, and he would take that money and pay back what he was supposed to be paying the first investors, 9%. That's what a Ponzi scheme is. Kind of like a pyramid scheme I may have heard from. You have to keep getting people to invest. and then you take new investor money, you keep a little, and then you pay off the old investors with the new investors. That's how he did it. Now, he had a business, this Bernard L. Madoff Securities, that did some real business. Right? It had some real, people would call in and they would use their money to buy trades, did some real business. But his fraud, he didn't buy any securities, any trades, nothing. It was all completely made up. That's what the evidence will show. So the first way in this situation that Ernst Young failed to do his job, Ernst Young literally failed just to make a phone call. Because remember, to give reasonable assurance, Ernst Young has to gather evidence. They can't just take someone's word for it. They have to gather evidence. And this is what the evidence is going to show. The broad market funds, remember that's our feeder fund. You know with me? Futureselect invested in the broad market funds that then invested in Madoff. This is how that worked. The broad market funds outsourced everything to Mr. Madoff. Everything. So if you were going to decide which investment to buy and sell, the broad market funds that Futureselect put his money in first, they didn't make any of those decisions. They outsourced that completely to Mr. Madoff. The next thing they did was the actual trades. So these fictitious trades, broad market funds, they didn't do anything. They said, Mr. Madoff, you're going to do everything. We're outsourcing it to you. You'll buy and sell and decide when to buy and what to sell. Here's an important one. Custody. Broad market funds outsourced to Madoff, actually hanging on to the custody of the supposed stocks, bonds, and T-bills. So if you went to the broad market funds and said, where's my stuff? Bernie Madoff has it. He's making all the decisions. He's making all the trades. He's keeping all the stuff we're buying. And not only that, he's keeping all the records as well. So he's also saying, oh, okay, I bought stock today, so I'm writing that down, although he's really not. And he says, oh, we made a dividend today, I'm writing that down. All the records, everything, the evidence will show, was with Mr. Madoff. Ernst Young's job was to audit the broad market funds. But there was nothing there. The evidence will show that the broad market funds outsourced everything to Mr. Madoff and his company, Bernard L. Madoff Securities. In this situation, the question is for Ernst Young, what do we do to find out whether those T-bills are real or fake? Well, Ernst Young admitted that that's the situation they found themselves in. Mr. Bwede said, that's me asking the question, I said, I think we've gotten that Madoff was doing all the stuff regarding the trades. Initiating the trades, he had discretion, he had custody, he would do all that stuff. But that Tremont itself would get from Madoff trade tickets, which they would keep from recording their books. Fair? Yes. So all that would happen for broad market is they would outsource everything to Madoff, and then Madoff would send them a ticket or a statement and say, here's everything you have. And Tremont would dutifully write that down. So in that situation, what was Ernst Young going to do to make sure that the T-bills were real or fake? Ernst Young told us at the time, Ernst Young wrote down in 2000, 2001, 2002, 2003, what their audit plan was to provide reasonable assurance that there was not a material misstatement due to fraud. And what they said they were going to do, Ernst Young said, we will review the final audited financial statements and partnership form K-1 returns from each prospective asset manager. The evidence will show that the asset manager was Mr. Madoff, not disputed. What actually happened? Well, at the time, Ernst Young wrote down in their what's called their work papers. When you do an audit, the auditing firm has to write down what they do, and you're supposed to be able to go back and look at what they did and see it from what they write down. Ernst Young wrote down what they did at the time. At the time, Ernst Young said that they, based on the information in this memo, this is a memo from Ernst Young. I'm sorry, eventually you'll be able to get to the whole thing. It's a couple of pages, and I have a certain amount of time to do this. But based upon the information above, and from the audited financial statements from the company, and the memo itself says, who's the company? Bernard L. Madoff Investment Securities. Ernst Young deems that the securities are adequately safeguarded and available to BMT and BM upon their request. That's what Ernst Young said they did at the time. They went and looked at Mr. Madoff, or Bernard L. Madoff Securities. They looked at their audited financials. So if that's what Ernst Young said they did at the time, what did the rules require Ernst Young to do? Because I think we maybe even heard this when we were doing the jury selection. Mr. Madoff's auditors, the ones that were supposed to be checking in his company for billions and billions supported in trade, was a company by the name of Freeling and Horowitz. And if you're Ernst Young and you see the name Freeling and Horowitz, you have no idea who this is. Because this is, in fact, it's actually one man in a little office outside of New York. And supposedly, at the time, if Ernst Young was reviewing Mr. Madoff's financial statements and relying on them, that those T-bills were good and good custody, then they would have found out that Mr. Horowitz was only one person supposedly doing an audit that would take an army of people days and days and days. But it's more than that. Because the rules required that if Ernst Young saw that the auditor for Madoff was someone you never heard of or you weren't familiar with, then you need to, what? Get reasonable assurance. Gather evidential matter. And they could have. Because this tiny single accountant operation that had conducted no audits since 1993, the group that actually governs auditors, the AICPA, they actually will tell you if someone's being peer reviewed, which is a requirement to do audits. You just got to call them. You literally just got to call them. And the evidence will show that Ernst Young said, we're going to rely on Madoff's auditor because everything that's happening is happening over at Madoff, not at the broad market funds. They're going to find out it's Freeling and Horowitz, some single-person operation that couldn't possibly audit Madoff. They know that there's supposedly billions in assets. And what are they supposed to do? They're supposed to call up the AICPA that governs auditors and ask, hey, is Freeling and Horowitz peer-reviewed? Because that means whether they can do audits or not. And at the time, the evidence will show if Ernst Young would have just made this phone call, as they were required to do by the rules, they would have been told no. The red flag is not just that it's one person who couldn't possibly do the audit. The red flag is that Freeling and Horowitz wasn't even approved to do audits. So at the time, Ernst Young would have discovered, if they did what they said they did in their work papers, they said they looked at his audits and saw Freeling and Horowitz, they would have known that this billions and billions of dollars purported operation the firm that was supposedly safeguarding these T-bills, wasn't even licensed to do audits. That huge red flag meant that Ernst Young could not possibly have reasonable assurance. This is what the evidence will show. Now you may think, look, if Ernst Young, resigns and steps away, that's a huge red flag and all kinds of things might have, could have, would have happened. Maybe that would have unraveled the Madoff fraud. I'm not going to try to prove to you that far down the line. I'm just going to prove to you that when Ernst Young did what they said they did at the time, they saw Freeling and Horowitz doing the audit. And that had to be a big red flag. Couldn't possibly be true. And they had to stop their audits right then and couldn't sign their name. That's what I'm going to prove to you. And that's the first way that Ernst Young didn't do their job. Now this seems like kind of bad. I mean, their own work papers say they saw Freeling and Horowitz, so wasn't that a red flag at the time? Well, after Ernst Young got sued, this was what they said. I asked Mr. Brady, did you look at BLMISs at Bernie L. Madoff Investment Securities? Are Madoff's audited financials? No. So if you didn't look at them, you didn't rely upon those in any way. We did not rely on them. No. I showed him the documents. Every BNY person we talk to now says, never saw them, didn't rely on them. But I'm going to prove to you more. I'm going to prove to you that EY failed to do its job. It didn't follow the gas rules and get reasonable assurance. Because Ernst Young just relied on what Madoff said and then compared Madoff to Madoff. Let me show you what I mean. Back to our example. Again, this is one of the financial statements for 1 year. This is the example we're using. 831 some odd million in treasury bills. That's what Ernst Young signs its name to. And I asked Mr. Benner what we've been talking about, another auditor for Ernst Young. Actually, this may have been Mr. Forrester. As an auditor, did you have an obligation to confirm the existence of those treasury securities? Yes. That was part of their job. Which audit assertion did the confirmation address? Existence. So what Ernst Young did to confirm the existence of the treasury bills after the whole Freeling and Horowitz thing is they asked Mr. Madoff, please confirm that you have all these treasury bills. Mr. Weddy said the same thing. When you're going to do existence, how did you do that? What did you rely upon? And he said, for existence, we looked at the confirmation that we obtained. Then I asked him, for value, is it accurate that what you did is you looked at the CUSIP number in Dow Jones? And he said, yes. This is an important distinction, okay? For confirmation, number one, existence. What Ernst Young did is they sent a confirmation to Madoff. That was to tell them whether the treasury bills existed. Other work they did, like comparing CUSIPs, getting a trade ticket and looking at the market to see if it was the right, prices were done that way, that was all valuation. Ernst Young did a terrific job of valuing fake securities. You're going to see all kinds of evidence about how Ernst Young went out, and they'll say they looked at trades, but they don't mean real trades. Right? What they would do is get a trade ticket with Mr. Madoff's name on it, and then Ernst Young would look into the market, not to see if that actual trade was real, but to see if the prices on the ticket made sense. Same thing with the QSIT number of the T-bill. Doesn't tell you who owns the T-bill, the evidence will show. It just tells you if that was the right amount or price on that day. Right? You couldn't look at it and say, oh, Mr. Madoff owns this T-bill, it's real, or Broad Market owns this T-bill, it's real. So whenever you see evidence that is not the confirmation about what Ernst Young did, think to yourself, they're valuing those fake securities. But the first question, whether did the Treasury bills exist, they testified over and over again that the basis for that was their confirmation, the one thing. So they sent this confirmation, and they sent it out, and Mr. Madoff sent back to them a statement. And you see it comes from his company, Bernard L. Madoff Investment Securities. But you will notice, and you'll see this over and over again in their work papers, Ernst Young doesn't draw a distinction between his investment firm and Madoff. What do they say at the bottom? Received directly by EY from Madoff. So they get a statement that says, okay, here's your year end, and what do we have in Treasury bills? $831 million. And where does that match? The anticipation. Did I go in the wrong order and mess this up? You're on the move. That's that number we've been seeing on the financial statement. So what was happening? Well, we asked Mr. Denizo, another Ernst Young auditor, what were they doing to confirm that these T-bills actually existed? And he's saying, my understanding is that the independent administrator tells you the value of the RI funds based on information that they have got from BMIS. So there's an administrator that helps the RI funds report things down their books. So they would get a statement from Mr. Madoff, and they would dutifully type it in accurately. We're not going to ever allege that these fake assets were not the exact number that Mr. Madoff told RI funds it was. They will type it down, and you confirm it how? And Ernst Young says, independently, we will confirm back and send a confirmation to BMIS. We've left out the L here. It's Bernie L. Madoff Investment Securities. Or whoever is the custodian of the assets, well, that's Mr. Madoff. In the case of the RI funds, was the custodian BMIS, yes. So you were confirming information that came from BMIS with information from BMIS. And the answer was correct. Mr. Madoff sent a statement out to the administrator. They would type it down for the RI funds. And then what would EY do? They would ask Mr. Madoff, was this right? And then they just compare the numbers. And so this is how it would work. The same statement would go to both. Now, the administrator would get documents along the way, the fake trade tickets too. At the end of the year, they would get the annual statement. They would type it down. It would go right into the broad market financial statements. And Ernst Young would say, well, I got the same statement, and they match. That's what the evidence will show Ernst Young did to get evidence, reasonable assurance, that the Treasury bills actually existed. The evidence will show that under the rules, that is not what you can do when Mr. Madoff is doing everything for the RI funds. Remember, he has all the books, all the custody, everything with Mr. Madoff. The evidence will show that at that point, where everything is with Mr. Madoff, that Ernst Young just couldn't take his word for it. They couldn't just match what he said to them and to the right funds. They had to actually look a little behind the curtain to see if the T-bills were real or fake. So at the time, Ernst Young wrote down in their own work papers all the time. They didn't have some big distinction between Bernard L. Madoff Investment Securities and Mr. Madoff. It was always just Bernie and Madoff and Madoff. That they were confirming with the investment manager, Bernard Madoff, Bernard Madoff, Bernard Madoff. Now, after Ernst Young got sued, you're going to hear a different story. Now Ernst Young's going to argue to you that no, there was this huge distinction between Mr. Madoff and Bernard L. Madoff Investment Securities. Not what they said at the time, but now they're going to say, no, it was BMIS doing everything. And, you know, the SEC regulated them, and, you know, they had part of their business was real, and, you know, we relied on that. And that's what they're going to argue to you now. The evidence will show that the truth is that at the time, the things Ernst Young wrote down over and over again in their own work papers was that they just treated him as Mr. Madoff. And there wasn't this big distinction. And why do you need the distinction? Because remember, everything is outsourced. Everything. The custody and everything. So, for example, if someone different had custody of the T-bills, you could just ask them, right? Or do these T-bills exist? And if they were really independent of Mr. Madoff, then that would work. That kind of confirmation would make sense. But the evidence will show where Mr. Madoff was doing all of it, he supposedly had it all, you just couldn't take his word for it. The fourth reason we're going to prove to you that he let Ernst Young fail to do his job is Ernst Young did not try to find the fraud. Again, I'm not going to prove to you that, or try to prove to you, that they had to find this fraud. It's not our case. What I am going to prove to you is that the rules require them to at least consider it for fraud. Our original standard, the auditor has a responsibility to plan and perform the audit to obtain reasonable assurance about whether the financial statements are free of material misstatement, whether caused by error or fraud. There's a whole standard all about what do you got to do, all the different things you got to do to consider and look for fraud. One of the things that the rules say you have to do, is this the rule or this is their statement. Ernst Young wrote its own memo, as they were required to do under the rules, about what they were supposed to do to look for fraud. And it says in their memo, we're going to summarize the procedures performed and information considered to identify the risk of material misstatement due to fraud. That's what they were supposed to do. And one of the main things they were supposed to do, and they identified correctly the fraud risk. What was the fraud risk? We're going to have a misappropriation of assets. That's right. That was the risk. And in fact, I asked Mr. Bleddy, do you have that? I said, down below we see misappropriation of assets. And he said, yes. And I said, do you believe that could apply to broad market funds? Is that a risk that you considered? He said, yes. I said, do you think that is what happened here, that the Madoff fraud, that there was a misappropriation of assets? And he says, we know now that the assets were misappropriated when they were sent to his care. He was the investment manager to trade on behalf of Tremont. We just leave that up for a minute. And then, sorry. I just want to point out here, I went back and forth with Mr. Bleddy, as you'll see in the evidence, about whether it was Madoff or BLMIS. But in this question, at least, he harkened back to the days when he was actually doing the audits, and he says, talks about him and his. In the next one. So I ask you, and again, the important point, the procedure that would address the misappropriation of assets in your mind was sending the confirmation of Madoff or BLMIS for the investments, yes. That's what the only thing they did to confirm whether they were real or fake. So what did the engagement team do to consider fraud and try to look for fraud as the standards require them to do? It says, we're going to have a meeting, that's what the standard required them to do, and we're going to discuss the potential for material misstatement due to fraud. Good. And what are the objectives of this thing? They say increase awareness and do these things, and what's a critical part that the rules require? For the executive in charge of the audit to emphasize the importance of maintaining the proper state of mind and level of professional skepticism throughout the audit. The guy in charge needs to be there, because looking for fraud matters. So then we look at their own memo about who showed up to the meeting for this important part of their job, the whole standard, look for fraud. What actually happened here? He didn't come. Mr. Brady came. Mr. Denizo, who's another staff member, came, although I believe Mr. Denizo testified he wasn't sure if he was there or not. But the partner in charge didn't even come. This is the rules and their own memo required him to do. So I asked Mr. Brady, now, part of your job, right? Part of your job, right under the rule we just read, is to look for fraud. He actually interrupted me. I think y'all are going to actually get to see the video of this, of Mr. Bleddy. There are some witnesses here that are across the country. We can't make them come. And some of those are going to come by video. Okay? At this time, we understand that Mr. Bleddy will not be coming to trial. And that may or may not change. Is that a fair statement, Your Honor? Mm-hmm. But if he doesn't come, then y'all will see his video of his deposition. And it says, question, when you're providing reasonable assurance, trying to find fraud, what are the, and he interrupts me. And he says, we are not trying to find fraud. I'm going to prove to you that one of the reasons Ernst Young didn't have reasonable assurance, they weren't trying. That's what the rules require. And he admitted they weren't trying to find fraud, which is right in the standard as part of their job. Now you're going to hear that Ernst Young, for these two audits, they didn't make a lot of money. They weren't paid that much to do this. And I appreciate that. That maybe they didn't think they were getting paid as much as they should have, or maybe they were and it wasn't enough. But that doesn't change what the rules require you to do. Ernst Young still had to follow the rules. That was their job. And the evidence will also show that Ernst Young was making plenty of money and performing plenty of work for the Rye Fund's parent, Tremont Partners. The evidence will show that over a period from 1993, I think, all the way through to, I think Mr. Blady testified he was still working this year, that Ernst Young did hundreds of audits for all different kinds of funds. That Ernst Young had over 9, I think I wrote this down so I make sure I say this right, before I get to this document. That actually, they had over 900 Ernst Young professionals working on Tremont-related matters. Tremont Partners managed the Rye Funds. So Ernst Young, they were all over Tremont and making lots of money for years and years and years and years. And in fact, after the Madoff fraud was revealed, they kept working for Tremont. And the evidence will also show that during the time period of these audits, that Ernst Young was doing something called surprise exams of Tremont partners that managed the RIE funds. And those are exactly what they sound like they are. You're supposed to surprise and show up unexpected and do an exam to find out who has custody of these assets who we're talking about, these T-bills and other assets. And the evidence will show that Ernst Young, for their surprise audits, showed up on the same time every year. Not much of a surprise. Ernst Young didn't do their job because, at least for these two funds, they weren't trying. So it's not just Freeling and Horowitz. It's not just sending out a confirmation. It's not just not even showing up to the meeting and saying they're not trying to do their job. When Ernst Young signs their name to these fake assets, it matters. And that's the next thing I'm going to prove to you. EY's failure mattered. And to understand how Ernst Young mattered, I think you need to understand a little bit about who was receiving that opinion from Ernst Young that these assets were real. So I want to tell you a little bit about Futureselect and Mr. Ron Ward. I'm asking to stand. Mr. Ward and his wife Diane run Futureselect. The evidence will show that Mr. Ward and his wife came to Seattle in 1978. And Mr. Ward's passion was investing. And he started to learn about how to invest. And at first he invested for himself. And after a little while, some of his friends became interested, and he started investing with his friends right here just outside of Seattle. And that's how his business started. And Mr. Ward ran Futureselect out of his home. I think he off and on had another office, and then you ran it out of your home for a lot of that time. Mr. Ward learned about investing, and he knew that to invest, and the people that invest with him knew that he could do some things, and some things he had to rely on professionals to do. And that's what the evidence will show. Mr. Ward, we get to hear from him. He created his own experience, and over time, his fund grew. What started out here outside Seattle with his friends here has grown, and now there's still individual investors in Washington, but most of his clients and most of his money come from around the country. I mean, he has all different kinds. There's a church in New York that invested with him, but there's also other big funds, and there's people, a simple way to say this, these are not, little old ladies who are putting their last pension check in with Mr. Ward. That's not who plaintiffs are, and you should think so. Right? Plaintiffs are largely people that have the kind of money.
Well, do we proceed?
These are people generally that have the kind of money you would think they would put in with somebody to invest. Some of them are investing in their retirement funds, and that's true, but some of them are investing a lot of other money with him. So, and I don't want to try to tell you otherwise. That's who we're talking about. And Mr. Ward was doing this in approximately 2005. He heard about the gentleman by the name of Bernie Madoff. There's something that Ms. Alexander wants me to do. Okay. Let me say this, and I promise that I will do this. And he heard about Mr. Madoff. Now, at first, Mr. Ward did not put his clients in. To test it out, for the first couple of years, he invested his own money. And as part of some of his investment, after that went, then he started investing with his fund, Futureselect, which is the plaintiff here. And in doing so, I think this is only for a small portion of the investment to start with, but Mr. Ward signed things that said, the investor acknowledges that in making a decision to subscribe for an interest, that's how you invested, he's relied solely upon the memorandum, the partnership agreement, and independent investigations made by the investor. That's the investor's Futureselect. The person actually doing all this is Mr. Ward. So remember at the beginning I said Mr. Ward is going to take responsibility here? Well, this was part of his responsibility. Mr. Ward said and did do his own investigation. Now, part of that investigation was getting information and relying on it from professionals like Ernst Young, that those treasury bills they had reasonable assurance that they were real. But he himself looked at the other things. So he certainly, in making the decision, looked at the returns. Right? And that was a factor that he used to make this decision, for sure. Now this is a memo that Mr. Ward wrote, I think, after the fraud was discovered, where he sort of detailed to someone what he did. But he explained, I put my personal money in, and after a year and a half of research, I was looking at this for a low volatility alternative. I'm going to let him explain to you someday what that means. But he also said, look, we thought access to Madoff was great because if you find someone like Monroe Trout or Jim Simons, then you go with them. I don't know if you all have ever heard of Monroe Trout or Jim Simons, but they were around the same time of Mr. Madoff. Have you heard Mr. Madoff was too good to be true? Have you all heard that? Well, it turns out he actually wasn't. Because Mr. Trout and Mr. Simons were investment managers who were kind of secretive, they wouldn't tell outside investors exactly how they were doing their trades, and they've done very steady, very success for years and years and years and years and years, and there was no big fraud. So he looked at Bernie Madoff, and Mr. Ward, I can tell you from the evidence will show and personal experience will show that Mr. Ward is dogged. And he will keep calling until he gets his answer. And one of the things he wanted to do was meet with Mr. Madoff. And not a lot of investors got to meet with Mr. Madoff, but Mr. Ward stayed after it, and he got to spend a few hours with Mr. Madoff. And he took a look at him, talked about what they were doing, and he said he thought he was down to earth and concerned about people. And he says, well, it appears we missed here. Mr. Ward takes responsibility for that. He met directly with Madoff, spoke to him, didn't identify after speaking to him for a little while, hey, here's a big fraudster. That was part of Mr. Ward's responsibility as part of his due diligence to try to meet with him, and he did it. He grabbed all the public information he possibly could. Now, there are these articles out there, which I'm sure Ernst Young, part of their job is to know the business they're auditing. I'm sure they looked at them. I'm sure Mr. Ward, I know Mr. Ward did too. Because he was always looking for information. And someone said, hey, don't ask, don't tell. And Mr. Ward knew that because he was not a certified public accountant doing an audit, that he was not going to have access to the numbers like others. That's why he tried to meet with him and judge him as a person. But he was not an auditor. And he knew that part of what he was going to have to do was rely on others. He said he read these articles, and I looked at them, we asked questions, we talked to people. There didn't seem to be any, at the time, there didn't seem to be an issue. At the time, there were audited financial statements saying at least the underlying assets are real. And the returns, steady, were great, but there were other people getting nice steady returns too. And he went to Tremont. Tremont managed them, was the managing partner. This is where Ernst Young was doing all these audits of all these funds at Tremont. That was who managed the Rye funds. And he said, look, I went to Tremont, and I contacted Tremont a couple of times a month. He called them up. He tried to gather all the information he could about what was happening in this investment. He says, I have a lot of confidence in Tremont's approach and their audit. At the time he wrote this, their current auditor was KPMG, another great big accounting firm. The auditors, Futureselect, that's part of what he relied on. It wasn't the only thing. And we're not going to try to tell you that Ernst Young's audits were the only factor why he invested. They weren't. But you can bring your common sense here, and what the evidence will show is that if someone would have said at the time, we don't have reasonable assurance, one of the biggest auditing firms in the world will not sign this audit opinion, that would have been a huge red flag. And Mr. Ward would not have invested if the information was actually fake. It doesn't matter if you're getting steady 9% returns. If it turns out, at the end of the day, it's all fake and you're going to lose all your money. That's what we're going to prove. So what we've been trying to prove in this section, that enterprise failure matter, is really Ernst Young matters. When the big four auditing firm signs their name, it matters. And it's recognized right in their rules. Ernst Young must follow, in this case, the ethical principles that include ET Section 53, the public interest. And it explains that certified public accountants doing audits matter. The very first sentence says that a distinguishing mark of a profession is its acceptance of its responsibility to the public. And then it goes on to explain who that public is. And that includes investors and governments, but not just that. It includes actually how we're doing business, the orderly functioning of commerce. I have a high phrase, but that's how much auditors matter as the gatekeepers. And it's this reliance by investors like Futureselect that imposes the public interest responsibility. What Ernst Young says matters. And Ernst Young ultimately had to answer that in this case. That we have a duty to the public to do our audits in accordance with the auditing standards. That public's the public right here in Washington, includes the plaintiff, Futureselect. This is what we did at the beginning, that they understand that we're doing their job. And Mr. Ward was asked, does it matter to you? Do you care that Ernst Young signs their name as the gatekeeper? And what he said Well, we wanted them to exist every year, and it's a cumulative effect. You know, we rely on all years to get us more and more comfort. We got more comfort when the Big Four firms started auditing the fund in 2000, and each year it builds cumulatively. If Ernst Young had found the problem in 2002, we wouldn't be investing in 05 and 07, 06 and 07. And that's what the evidence will show. If someone told you in 02, hey, we can't tell whether these exist, whether they're real or fake, that doesn't mean you're going to go, oh, okay, well then I'm going to keep investing. Of course you wouldn't. You would be out of that investment. We're not going to try to prove to you that Ernst Young was the only factor. There were a lot of factors. Ernst Young started doing the audits of this fund, the first Big Four fund to audit this fund, in 2000. And what we're going to prove to you is that after that, Ernst Young was a factor in the investments. How do we know that Ernst Young should be a factor after they started putting their name on? Well, this is Ernst Young's own expert. And we asked Ernst Young's own auditing expert, meaning up until the detection of the fraud, which I think happened in late 2008, Ernst Young understood that its opinions in 2000, 2001, 2002, and 2003 could be relied upon. Correct? And he said, I mean, Ernst Young knew that they were performing an audit for the funds. They issued an opinion on those funds. They were aware that the partners of those funds might get those financial statements because they were addressed to them, and they stood behind their audits. And so what does that mean? It means Ernst Young stood behind its audit opinions of the RI funds. By the way, sorry for the aside, RI funds, broad market funds, same thing. In the middle, they changed their name just to make it confusing for us. Right? It's actually the same funds, okay? Ernst Young stood behind their audits in 2004. Yes, I believe so. 2005, I believe that's correct. 2006, I believe that's correct. 2007, 2008, he says, well, in December 2008, the fraud was discovered. And he says, Ernst Young would have stood behind their opinions and their audit work as they should. The evidence will show that Ernst Young never came out before Madoff fraud and said, hey, all you investors, don't rely on our opinions anymore. Just like their own experts said, it was reasonable for Ernst Young to be a factor of something that Futureselect or other partners would rely upon. After Ernst Young said for 4 years, there was reasonable assurance. Because just think of it. If someone told you, hey, I want you to invest with me, but a couple of years ago, Ernst Young refused to issue an audit because they couldn't tell if my stuff was real or fake, that would be a factor, and that's what the evidence is going to show. Now, y'all need to know, remember I said Ernst Young was the first Big Four, but there was another auditor before Ernst Young, and that was GGK. That's a smaller firm, not a Big Four firm. I don't know where they land in the big hierarchy, but they're a smaller firm in New York. And they audited the firm first before a Big Four came on, where they needed to get more money. GGK, is GGK a factor? Sure. Was that one of the things that Mr. Ward considered when he was investing? Yes, it was. When KPMG came on, was that a factor that Mr. Ward considered when he was investing? The evidence will show, yes. Now, you can argue with, maybe the evidence will show that KPMG was, hey, when GGK or EY would have found it, then, not our fault because we wouldn't even have been here. Or maybe you'll determine that KPMG is a bigger factor. That's up to you to decide. But what I'm going to prove to you is these were all factors. Okay? They were all factors. Mr. Ward invested with other funds doing Madoff. All right? Write that down. He did. Okay? Was that a factor? Sure. Of course he considered that. He considered, like any reasonable investor would, all the information he could get his hands on. So Mr. Ward and Futureselect, what happens here is the person before you, for you to decide about, is Ernst Young. Right? We obviously believed other people were responsible as well, because we sued them in this court. And that lawsuit included the other auditors and Tremont, who was managing the funds, and I think actually the parents would be responsible if Tremont was responsible. That's Oppenheimer and Mass Mutual, but we sued these other people. We clearly believed they were a factor. Now this lawsuit was brought years and years and years ago. It takes a long time and a lot to be able to present your case to a jury like you. And when we brought our lawsuit, we didn't have the benefit of all this testimony that you're seeing. We just had public information. And we brought our lawsuit, and then afterwards we were able to take their deposition and find out more and more about what Ernst Young had done. So before we saw their work papers, we didn't know they'd written in their work papers that they relied on Madoff's audit. Right? So now, after bringing that complaint and having the chance to look at the information that we have now available to us, that's one of the reasons when I say here, learning all about the Madoff fraud, we're not trying to convince you that their job is to unravel the whole fraud. We're just trying to convince you, and I believe that evidence will show. They just didn't do their job. And we just want to hold you responsible for what they did. Her Honor instructed you at the beginning that we brought these cases against others, and that, in fact, you're not to consider, trying to remember Her Honor's words as best I can, Your Honor. Basically, you're not to consider that some of that is concluded, some of it may still be going, you're not to consider it. And earlier, when I said the only one left in this courtroom who was not taking responsibility is Ernst Young, I didn't mean to imply, if I did on this break, I didn't have a chance to look at the transcript, that you should do anything but do exactly what Her Honor said. But all I'm saying to you is, in this courtroom, Mr. Ward is going to take responsibility. Ernst Young is going to stand before you and say that it confirmed, signed its name to $4.2 billion in fake assets over 4 years, and they don't have any responsibility. That they're not a substantial contributing factor. We're not going to prove to you that they're the only factor. We have to prove to you that they're the factor. We're just going to prove to you that they were a factor. And Futureselect losing over $100 million. And this is another of Ernst Young's experts, and he sort of, in this answer, got to the crux of it. He was asked, if the financial statement said none of the assets are real, do you think that the investor would have made a decision based simply on the financial statements? And he said, you know, if the financial statement says the assets don't exist, then we didn't have a hedge fund. There wouldn't have been money invested. That's their own expert. And that's our. When Ernst Young hadn't been sued, they talked a different language. I showed you what was in their actual work papers and what they said at the time. At around this same time, 2005, Ernst Young said, we're delivering on our promise. You can count on us signing our name there. It means something when we say we have reasonable assurance that there's no material misstatement due to error or fraud. Ernst Young says, our promise matters. Now, they acknowledge in 2005 that over the past few years our profession has been subject to intense scrutiny and criticism, but they say they're emerging. And what do they say matters? We look down below. You obviously read anything, you'll get this document as well. Is the affirmation around the globe is that what we do does matter. That's our case. Ernst Young, what they do matters. They are a factor. And what did Ernst Young promise? That they were gonna be accountable when they did their work. This was their promise. We are accountable not only to our clients, in this case that would be Tremont or the Rye funds, and our regulators, but also to the investor community. That's us, the investor. We're not asking you to find that it was just Ernst Young. We're just asking you to hold them to what they did when they signed their name. I believe I am almost done, Your Honor. I know y'all are tired. Can I just check with Miss Alexander, and then I'll come back to you, and I think that will be it. What we're asking you to do is to hold them to their name. So now, what I told you I was going to prove, you hold me to it. And whatever they tell you they're going to prove, you hold them to it too. Because when you sign your name, it matters. And this shouldn't treat me like a politician who goes off to Olympia or Washington. I say I'm going to prove it, and I don't, and I come back, and who knows what happens a few years later. I will come back before you. And what I tell you I'm going to prove, you hold me to it. I have another marker. I've left this one out. They got it all dry. So, and you should be able to read this. Y'all hold me to it. Make us prove it to you with evidence. And when we do prove it to you, I'll be back to ask you to award the fair amount for the plaintiff, Futureselect. You counted on us, you know.
Thank you, ladies and gentlemen of the jury. I think what we might want to do is take an early lunch break. Mr. Bennett, do you have an objection to taking our lunch break at this time, or do you wish to begin your opening and break in the middle? Normally, ladies and gentlemen of the jury, we break from noon until 1:30. Maybe because we're at a point where we could break early, maybe we could come back and actually begin at 1 o'clock rather than 1:30. Mr. Bennett, would that work for you and your team?
Of course, Your Honor.
Mr. Thomas, any objection to that?
No objection. Thank you.
All right. So then, ladies and gentlemen, this is your first lunch break of the trial. You are free to leave the courthouse to get lunch. I just ask that you be very careful about who you're listening to out on the street or where you might be going to get lunch. My request is that you do keep your juror badge visible so that if there are attorneys or witnesses who may happen to be in the same location you are having lunch, that they'll restrict their comments within earshot of you. That's the best way we can to make sure everybody knows that they shouldn't be talking about their case close to you. I'm going to give you the recess instruction again. Please do not discuss this case with anyone, including family, friends, colleagues, people out on the street, potential people associated with the media, any lawyer, party, or witness involved with this case. If you believe that anyone is discussing this case within hearing of you, please indicate that you are a juror on the case, and that you need to move away from the person having that discussion. Please do not go out onto the internet or refer to any media sources that could be reporting on this case or could be showing excerpts from the trial on the internet. Please keep your mind free and clear of anything outside of this courtroom. You may not do any independent research on your own. You may not Google any of the names that you've heard in the course of the trial so far. Again, please, please, please be careful about inadvertent access to information about this case. With that, I will ask that you return here to this courtroom, go immediately to the jury room. If we want to start by 1 o'clock, if you could be here no later than 10 minutes to 1, that should give you and us plenty of time to get things in order and be ready to begin with Mr. Bennett's opening statement at 1 o'clock. Thank you very much. We'll be in recess.